good night. This is U.S. immigration attorney Sharifa Tharb. I'm here live to take your U.S. immigration related questions. Go ahead and put your questions in the comments now so that I can get to the answers to your questions. Now, I am here energized because I want to tell you that there are ways to fix your status. If you are here, and I want to focus on one particular area tonight and talk to you about the possibilities, because a lot of people think if you have an offense in your background, there's no way you can come forward and apply for immigration relief. And so those individuals stay vulnerable to immigration enforcement because they're not taking action because they may have a misdemeanor or a felony in their background and they think there's no legal solution to that. But I'm here to tell you that there are legal solutions. Even if you do have an offense in your background, it's very important to get in touch with us and talk to us about it. For example, there are types of waivers that we can apply for to get forgiveness. But if you don't apply for it early and you end up being deported, then it's going to get a lot harder. Or you end up in immigration court, you may not have the ability to proactively apply for a waiver. And it's going to be a lot more complicated and a lot more stressful. And the likelihood of you remaining detained is going to be increased if you do not seek a legal solution from early on. Now, at every step of the process, guys, there is a legal solution. There are possibilities. But what we are doing, we are representing clients, whether you have applied for immigration relief, you've never applied, or you're in removal proceedings. We are here for you. We are defending clients before immigration court against deportation. But what I want to do is make sure I'm catching people before a situation like that happens. Because if a situation like that happens where you're detained, it gets a lot harder. It gets more complicated. Now we're in it, we're helping clients, but communication is much more limited because you're detained. Access to evidence also limited because you're detained. Your family members, oftentimes when we are working to defend clients, we have to work with the family members very closely. And family members may not even have the kinds of details that we need from the client directly. So even though we do get those details, they're delayed. So this is where I say contact us and start from early on. Can't stress that enough. It is so important for you to be able to be proactive for yourself. And the least you can do is contact counsel, and as in you can also contact us and seek a confidential evaluation, consultation to determine what's the best option for you. Hi there, Judy L. It's nice to see you. I'm glad you could join the live as well. So make sure that you're taking action because there are ways to fix your papers, even if you have an offense in your background. So just because you've had an arrest, just because maybe a misdemeanor, maybe a felony, what we do is we still evaluate, are there legal solutions that can help you to be able to obtain your status here? And then if we see that you qualify, okay, the next step is, can a waiver fix your situation? We've done this with the T visa. We've done this with the U visa. We've done this with the green card. We've done this under FAWA. There are ways to get forgiveness, but you have to be proactive. And keep in mind that your best shot at making it, keeping yourself out of detention, while it is stressful all through the process, whether you're detained or not, I can tell you that when you're detained, anybody can know that being detained is going to be a lot more stressful and it's stressful for the person detained most of all. So I am trying to prevent that from happening by helping people to understand it's important to step forward from early on. And I've been saying this from the get-go: explore your options. Like some people, well, I'm not sure if that's the same stance right now, because the way that this administration has the kind of environment they've created is an environment where they're putting immigrants, whether you're legal or not, between a rock and a hard place. So there is very limited protection if you do not have some sort of legal process or pending process moving forward. Of course, you do have to qualify for that, and that's exactly what we do. We explore whether you can qualify for one of those legal options. Now, I know we see in the news people are losing their TPS status. That's the latest thing. Supreme Court just came back again and said, and I did have a hunch that that was going to happen, because the Supreme Court has always backed the president's authority to end TPS. So this is just an example, though, of a type of legal authority that the president has. The president has the authority to terminate TPS. That has never been a surprise to any attorneys. It's a discretionary benefit. But the kind of benefits that we work on are written in the books, meaning Congress are the ones that created the law, and Congress has to change those laws. The president only enforces it. So the president and the immigration office still has to look at the law, look at the case we're presenting to them, and if our client matches the qualifications under the law, it must be granted, right? That is why we are still getting approvals and we're still getting results for our clients, because it is not discretionary. Yes, they can change some of the ways that they look at the policies, but at the end, and change the standards, but it doesn't mean that that goes away completely. The law always gives the base requirements for these types of benefits. And when I talk about them, it's the green card, getting the green card, VAWA, getting protection from deportation under VAWA, T visa, U visa, asylum. These are written into law. That's why we're still getting them. So go ahead, give us a call. We are working 24 hours a day. Thank you so much for the gifts. I appreciate it. And the love on TikTok. And why that's so important is because you're letting other people know and letting other people see the information that can empower immigrants through their immigration journey. You don't have to ask if you can ask a question. Put your questions in the comments, and I'm going to get to your questions very shortly. But I usually start by just giving you some information that I believe will empower you through your journey and help you to determine how you're going to seek help. So get into, hi there, Alicia. Thank you so much for the gift. So go ahead, give us a call now and let's talk. You can DM us as well. Give us a call. On our phone number is going across the screen. And I believe on TikTok, the phone number is at the top of the comment section. You'll see my name as host and you'll see the phone number. Give us a call right now. They will do a free initial evaluation. It's not a substitute for legal advice. It's not legal advice, but what it does, the question I often get is, I just want to know first before I pay for a strategy session, whether you can help me. And that's the purpose of the initial evaluation, is to determine whether you could possibly qualify for an option that we help our clients with to fix their status, to get their work permit, get their green card here, and get protection from deportation. So get in touch with us now. Our staff, they are waiting. And here at the firm, I do have a large team of people. We have over 30 team members that works every day to make sure that our cases are moving forward. Right now, we have for attorneys, including myself, and attorneys, a network of attorneys that are helping our clients to get forward in their legal process. And we work very closely together to make it effective. So we offer results that you can rely on, but you have to take that first step to determine what is best for you. And I know there's a lot of scary things going on, but this is what gives me comfort, is sitting down and watching the results of my clients come in, knowing that we are making a proactive move on behalf of our clients that's going to put them at an advantage. And so you can put yourself in that position as well. So give us a call. Now I see questions coming in. I love that. Always great questions. So I'm going to go ahead and start answering questions. There's always a lot of questions on TikTok. So I'm going to work my way from TikTok, then YouTube, Facebook, and then Instagram. So hang on, everybody, and I will get to your questions ASAP. I sent an expedite to NVC and they denied it, saying I was documentarily ready. What does it mean? So you're documentarily qualified already, which means that they have everything they need to schedule an interview. Now you're just waiting for an interview to be scheduled. Maybe the request had said, can they expedite that part of it? You may want to clarify that you need your case expedited for the interview. Now, if you're going to have your case expedited for the interview, they are very, very strict about getting evidence. Usually, they want evidence of a medical situation, urgent medical situation, humanitarian situation to be able to grant the expedite. And the NVC sends it to the embassy and then asks the embassy if they're willing to expedite the interview. So it may be the way that it was termed that, they didn't process it the way that you were thinking they would. Still calling interviews for VAWA? Yes, they are. Just be prepared. Now the interviews for VAWA, when they do the interview for VAWA, what happens is, as a result of the fraud that was taking place, there are a number of big cases that happened. For example, in New York, where someone single-handedly submitted many applications that remotely qualify for VAWA. And this is so irritating. And that's why, guys, don't go to non-attorneys and have them filed. Don't have a non-attorney just tell you they can get you the work permit and you don't know what they're doing, because that's what happened in this case. People were going to non-attorneys because they're trying to cut corners, trying to get it cheap. If it's too good to be true, it's too good to be true. So these people said, don't worry, I can get your work permit, I can get your travel document and get your green card. And they didn't explain how. They just said, don't worry, it's legal, you'll get your stuff. They started to see work permits coming in. And so people started to spread the word that this person is really good, they're getting people work permits. But what was happening is, yeah, they were getting work permits, but based on applications that were not legally sold. They were not legally qualified. So immigration, upon reviewing the application, started to realize they were issuing work permits to people that did not qualify based on fraudulent applications. So now they're doing interviews to make sure that people, when they're submitting these applications, they're submitting true information. It really happened to them, that they understand what's in their application for the VAWA. So, make sure when I am working with my clients, we don't send any applications out where our clients don't look at it first. They look at it, they review it, they make sure it's all accurate, that they agree with everything, that it all happened, and then we send it out. Any diligent lawyer is going to do the same thing. Don't let anybody submit any documentation without you knowing what they're submitting and without them explaining and for you to understand what they're doing. So yes, they're still doing VAWA. interviews, just understand what's in your application, be able to answer the facts to the officer about your VAWA application. So, and then everything should be fine there. That makes it bad for us who have legit cases. Exactly. That's the thing. Is you have so much fraud, and it does make it bad for everybody involved. I'm a widow. I have been trying to get my widow, and I'm thinking your green card based on being a widow. We help with that, and you must file this within 2 years of the death of your U.S. citizen spouse. You can get in touch with us and we can talk. I have removal of conditions to do. Get in touch with us. We do that as well. Please get in touch with us. Don't go through these processes on your own. Now that we have this administration, it was complicated before, but now missteps can mean denials and a swift referral to immigration court for deportation. So please get in touch with us. Talk to us about your situation. We can help. If you have to removal of conditions, that's where you're going from a 2-year green card to a 10-year green card, and you don't have your spouse involved anymore, there are still legal options available to apply on your own. But you must make sure you're applying on time, or if you haven't applied on time, talk to us still, because there may be a way to get it excused, so even if you're past the deadline. But you must do that now so that you can get back on track. Come through the border and married U.S. citizen, applying I-130. How can I terminate my removal case? So keep in mind that just because and this is what I need everybody to understand, marrying a U.S. citizen is not an automatic grant for the green card. A lot of people have the misconception that just marrying a U.S. citizen is going to make everything okay. In this case, you came through the border. My first question will be to you: do you come through the border? Were you granted parole at the border? If you know, parole doesn't mean conditional parole, where they said they're releasing you, but you have to make sure they're releasing you under the condition you show up for your removal case. That's conditional parole. Did they grant you parole based on humanitarian reasons? If that is the case, then you may be able to do adjustment of status through your spouse or before the judge. So they do allow adjustment of status before the judge. You don't necessarily have to terminate your removal case. It just depends on what the judge decides to do. Sometimes the judge will continue the case pending the I-130's approval, or terminate the case, or you could do it before the judge. Now, if you came through the border without permission, meaning you were never inspected, marrying a U.S. citizen is not going to fix the situation, and it's not even going to fix the situation for adjustment of status before a judge. So it's important for you to understand that there's a level of complexity there. Now, here's an exception. If your spouse was mistreating you, it doesn't seem like that's the case here, because you're applying for an I-130, which means your spouse is all in. But if your spouse is mistreating you, then you can apply for VAWA regardless of how you enter the country. VAWA allows you to get the green card without a spouse who's mistreating you. But we would have to talk to you to figure out your circumstances and determine what's the best legal solution for you. And you can also do VAWA before a judge in court as well. Can you adjust for F1 visa if you overstayed? It's possible, but adjustment of status, whether you can do adjustment of status, that means that apply for the green card while in the US, is going to depend on who you're applying for, right? I mean, who you're applying through. So who is petitioning for you? If you overstayed, and is it based on a family relationship? And what exactly is a family relationship? Are you the immediate relative of a U.S. citizen? Overstaying an F1 visa and being the immediate relative of a U.S. citizen means that you can do adjustment of status regardless of the overstay. But if you fall into another category, now I want to make this clear. Immediate relative of a US citizen is a spouse of a US citizen, a parent of a US citizen, and that US citizen is age 21 or older, or the son or daughter of a US citizen who is under 21 and unmarried. If you don't fall into any of those, you're not an immediate relative of a US citizen. That means if you're 21 or older and you're the son or daughter of a US citizen, you don't qualify as the immediate relative of a US citizen. You fall into a different category. Now, if you overstayed already and you fall into that other category, unfortunately, adjustment of status is not going to work unless you are unless there is an exception under VAWA. So this is where I say, give us a call, let's talk, and then figure out the best legal solution for you. And we don't just, we in our appointments, what's great about our appointments is that we don't just ask about, we're not focused on one solution. We are looking at multiple solutions that you have not even thought about, right? So you may be thinking, maybe I can get married, but we're thinking about solutions that doesn't require you to get married. We're thinking of alternative solutions to a relative or to an employer. We ask questions that other lawyers may not necessarily ask. Not a lot of lawyers ask. I know this because many of our clients come to me as a last resort just to get that last opinion. And then they realize, wow, the other attorney didn't say anything or ask any of these questions. That's how we get to the root of possibly multiple solutions and solutions you haven't thought about. I'm a green card holder filing for my husband. How long will it take? So it depends. Is your spouse outside of the US? If your spouse is outside of the US, I would say prepare for a 2.5 to 3 year process. Now, the first thing you have to do is file the I-130 petition and wait for your priority date to become current. Once your I-130 is approved, it's sent to the embassy. So it's going to be sent to the embassy where they will go ahead and start processing the paperwork once the priority date becomes current. That's like a waiting period, right? Once you get to the top of the wait list, then they start to process it for the interview. If your spouse is in the US and your spouse does not, they already overstayed their visa, then there is an issue. We need to talk. If your spouse is here and your spouse is under current status, their status has not expired or they have not overstayed, we also need to talk because we have to look at whether their priority date is current and whether they can then use that timing to apply for adjustment of status while being in the US and while still being in current status before they overstay. So essential. So I would say if you're the spouse of a green card holder, the son or daughter of a green card holder, and you're here on current status, you know you have a pending petition, get in touch and let's figure out if it's the right time to file that adjustment of status while you're here in the US. That's still possible. That's still written in the law. How long after USCIS say they receive RFE after interview, they make a decision? So I've seen it anywhere from 4 weeks to 4 months to even up to a year to get that final approval. Come through the border and married US citizen. Okay, so I answered that. Can you get F1 after you overstay? It's unlikely if you're here in the US trying to get a status. And they may hold it against you if you're going back to your embassy applying for a student visa there. So, unfortunately, so this is in Spanish. I can understand what it's saying, but we do speak Spanish in the office, and you can always call the office. But this question is asking how much time does it take to get the travel document in the case of FAWA? Now you've been waiting 12 months. Keep in mind that it can take about 12 months. So my experience is 6 to 12 months for a travel document and work permit. Now, one thing I want to say here is a lot of people, I don't want you to be short-sighted, right? So when I say that, I mean, when I say, oh, the work permit will come in 8 months, someone will say, "Whoa, that's a long time." However, just having a pending process puts you at an advantage. And before you know it, that time is here and you have your papers. This is what happens. And why am I saying this? Because this happens time and time again with my clients. They are so elated to have that relief, and it is so well worth it. After, yes, the worry and the anxiety, but we're used to those timelines. The clients is much more, it's urgent, right? But if you don't make a move, you will never get it, and you will continue to be in a vulnerable situation. And along the way, for example, the T visa, you get your bona fide determination letter within a shorter period of time. That alone protects you from detention and removal proceedings. And if you're in removal proceedings and you get a bona fide determination, it halts those removal proceedings. Then you can get your work permit. So yes, there is a wait time, as with everything in immigration, but if you don't start, you never get to it. And if somebody's telling you, I can get you the work permit in a month, that is not true. Those are unicorns. It has happened to us, but those are unicorns. So don't fall for anything that sounds too good to be true, because it probably is. Case was denied because of affidavit, and I did a appeal. Do you think they will reconsider the case? Sometimes doing an appeal may not be the best approach. I don't know your case. I'm not your attorney. Sometimes appeals can take longer. I don't know if you had an attorney who weighed the option, the pros and cons, and went with an appeal. Sometimes refiling as soon as possible before they issue a notice to appear is the best way to move forward, especially with an affidavit. And it depends, right? Will they reconsider? If they've made a mistake, they could reconsider. If they look at the affidavit and they see you clearly qualify, and they made a mistake and disqualified you or denied you based on the affidavit, then that would definitely be a winning case. But I'm not sure here if that's the case. Now, with appeals, usually you can't submit. So, for example, you can't redo the affidavit and then appeal. That would be where you would have to refile. Or you could have try to reopen the case as well. How long will it take to get biometrics appointment for T visa? So right now we're seeing anywhere. So it's taking 3 to 4 months just to get the receipt notices, and then about 2 months after that. So while we're hoping that they will stabilize, we've seen this before. I've experienced this before, especially when there was a transition from Trump to Biden. There was also a long delay in getting receipt notices. We're seeing that here with the transition from Biden to Trump, even though we're like almost a year in. But hopefully that will stabilize. We'll start getting receipt notices again within 2 weeks of filing, and then we'll see the biometric within usually 6 weeks to 8 weeks. But right now, receipt notices are taking about 3 to 4 months, and then about 2 months after that is the biometrics. Thank you so much for the gifts. I-130, I've been waiting for work permit for 4 months. Is that normal? So I'm a little concerned here, because I notice you say I-130. You filed I-130, but the I-130 does not get you any work permit. The I-130, guys, cannot even get you the green card. The I-130 is, and when I say that, if you're in the United States, you file an I-130 petition, you are not going to get a green card with an I-130 petition. You must file, if you're here in the US and you'd like to stay here in the US and get your green card, you must file an adjustment of status application. The adjustment of status application is what triggers the work permit and travel document. If you filed an I-130 without an adjustment of status application, you will never see a work permit coming. Now, I don't know if you're just bundling up all the documentation into just saying I-130, but when I see I-130, that's what comes to mind is, did you file an I-485? Because I-485 is what gets you the work permit, not the I-130. So keep that in mind. Now, if you're living abroad, you file the I-1, you're asked about getting the work permit in relation to the I-130. But I just want to add here, when you're outside of the US, you file an I-130, that is also step one of a multi-step process. You file the I-130, then it goes to it gets approved, it goes to the embassy, the National Visa Center. The National Visa Center then will issue an immigrant visa application for you to complete, and then they ask for supporting documents to go with the immigrant visa application, as well as fees. So the application fees to go with it. So I-130, filing the I-130 is just step one of the process. Okay, I'm going through and answering more questions. I'm seeing a ton of good questions. I had an arrest on 2023 and I paid for charges and after got dismissed. Can I apply for N400? This is very important for you to get in touch with us and let's carefully evaluate the charges. It's possible. Yes, absolutely. And I would say the first step is get in touch with us because now it's going to be a lot more involved. You do have to provide the sufficient documentation, but it's absolutely possible. But we want to know, what are those charges? That's going to be very important. We have to understand, because there are some charges that come with mandatory bars to citizenship. There are some that you may be able to show rehabilitation and still move forward. They're going to want to know that the additional documentation. They want to see that evidence. We know what to provide. So get in touch with us. Let's evaluate it and then move forward. I filed the N400 for my daughter and she did the biometrics. How long does it take to complete the process? So right now we're watching based on the new changes. But I would say, based on this is historic experience, we might see it change. And what I can tell you is, I do have that perspective because I did practice under the the first Trump administration. I practiced most of my time was in that administration practicing immigration law. So when I definitely knew what was coming when he came back. But what I can tell you is processing times ballooned from a very short time, from a 6-month citizenship process to an 18-month processing time. We might see that happen again. However, what I am seeing, citizenship usually takes 2 to 6 months to process. The important thing, though, is you need to be prepared for what to provide to the immigration. And it also depends, though, on when you applied. Because if you applied at a certain time, those changes that they've implemented may not apply to you. If I get married on an O2 visa, is it okay to go back to Jamaica and return to the US and do AOS? Give us a call and let's talk about that. I'm not sure. You're O2 as a child of an O1, and why do you need to leave to come back? We'd have to get more into detail there. What's next after doing biometric for T visa? So if you haven't had bona fide is coming, and then work permit. You can look forward to that next. Could I, as a citizen, sign for my sister-in-law to come back to USA? She's a non-citizen. No, so you can't file for sister-in-law. Is interview mandatory in marriage-based green card inside USA? Yes, it's as good as mandatory. It's as good as mandatory. They are now putting interviews in place again. Could I, as a citizen, so I answered that. Can someone who has overstayed B2 after passing NCLEX exam get a school in the USA? So they have not prohibited those who have overstayed from going to school. We're seeing changes in from state to state, and it depends on the state that you're in. But it's still possible they will treat you as an out of state in some states, so where you have to pay double the fee. And keep in mind that if you've passed the NCLEX, so this, I believe this is for the nursing, keep in mind that some states have regulations that may stop you from becoming practicing because of the lack of immigration status. Is interview mandatory in marriage-based green card? To answer that. All right, so now I'm gonna move over to YouTube and Facebook. Thanks so much, everybody, for waiting. And on Instagram, I'm coming. So just hang tight as I go through the questions. How much longer for a decision on T visa filed February 2024, no bona fide letter or EAD? So right now, processing times have ballooned to 22 months. So we're seeing almost 2 years right now. Greetings. How long are VAWA package receipts taking currently, please? 3 to 4 months. I'm hoping that will settle down and we'll go back to 2 weeks, but for now, 3 to 4 months. And this is because they're changing processes in the backdrop. And also, people are applying, they're making sure that they are submitting applications. So they're processing tons of applications while also dealing with the changes. So it's taking time, but I'm hoping it will settle in and we'll start seeing those receipt notices come sooner. So my child who is 25, status was changed, the NVC was written, and they admitted to their wrong, but the case still not changed back. It's 3 months now. She was 19 at start of filing. They said in the email she would be back to IR2. What can we do? Get in touch with us. It sounds like there's a complexity going on. So you said they admitted to their wrong, but the case still not changed back. Okay, so they admitted they were wrong. So in this case, I'm glad you mentioned this, because if they have admitted that they made a mistake, you can request an expedite. So an expedite can be made based on their error. So the fact that you do have evidence that they made an error, you can request that it's expedited, since they are the ones that made the error that caused the delay. How much to guide to N400 interview soon? Give us a call and talk to us. Let's talk to you about the situation and get started. Keep in mind that there are a lot of changes with citizenship. And this is why I say you need an attorney. This is an investment, and you should not be, this is your future in the United States. At the point that you're going for citizenship, you've invested a lot. And now is not the time to have missteps. The citizenship process is nothing to play with. They're doing neighborhood checks. They're now looking at additional evidence. They are making it mandatory that you show how is it you deserve to get citizenship. And so there's a lot more involved. It's not just filling out documents and submitting it. There's going to be a lot of evidence, and you have to make sure that you can show the officers through your documentation that you are qualified for citizenship based on the new standard. So get in touch with us. We are helping people to move forward under these new regulations. How long does U visa take to be approved? So right now we're seeing up to 10 years, but you do have the work permit, you have deferred action that can take 2 years, so up to 2 years. Can someone on paternity leave take another job I'm not sure I'm not sure if that's immigration related. Doesn't sound like it. Sounds more employment based. How long is VAWA renewal of work permit taking? I'd say expect 6 to 12 months still. VAWA case I-765 approved, but I-131 still pending, almost 11 months. Is VAWA case with adjustment of status. How long does it take? So I've seen that before. If you have an emergency, you can submit for an emergency travel document, but I would say, over a year. It could take up to the full year to get that travel document. Yeah, so it will take, because what they're doing is prioritizing the work permit and not so much a travel document. So if it's an urgent matter, you need to make them know too. How much to guide? Let me see. When you're using the term spouse in a VAWA case, does it only apply to people who are married and going through abuse? Yeah, now under the VAWA, there are three types of people that qualify for VAWA. The spouse, so yes, I'm talking about them being married. The parent, if the parent is being mistreated by a US citizen son or daughter who's 21 or older, or a son or daughter who is being mistreated by a citizen or a resident. And same with the spouse, you can be the spouse of a citizen or a resident. Now, if you are not married, this is where I say once again, you're not married, we look at options that may be available to you if you're being mistreated by a spouse, by an individual, your intimate partner who is not your spouse. Then we look at legal options available that can provide you relief. And we have gotten this for our clients. So get in touch with us. This is where I say, don't assume. I am just covering portions of what we do here at ST Law Office. So this is where I always stress, make sure you are getting in touch with us and talking to us about your situation. We start with an initial evaluation, and then we ask very broad questions that gets to the root of your circumstances, and we hone into that allows us to find your solutions. So get in touch with us. That's the way that can be done. So don't assume that you don't qualify because you're not married to a US citizen or a permanent resident. I have I-485, married to a citizen. I applied 3 months ago and I did biometrics. My work permit still not received. Do you think it will take longer? Yes. So I say for marriage based and family based, 3 to 6 months for the work permit. My USCIS account said 4 months the final decision. It may not. Don't hold your breath. That's the advice I'll give to you. Hi, put in my citizenship this month, will be 2 months. Have to do any community service? Is it okay for now? What I would say here, do you have to do community service? Not necessarily. This is where I don't want people to misunderstand, because I don't want people to think that because you didn't do community service, you can't qualify for citizenship. That's not what it's saying. It has a broad list of things that they are going to look at. Community service is one of them. But just because you didn't do community service doesn't mean you don't qualify for citizenship. but they're going to look at your life and they want to look at it from a holistic perspective to determine, have you been doing good in your life? Have you been taking care of your family? You may be working so much, you don't have time to go and do community service. You're trying to keep your family stable. You're trying to keep your head above water. So you're not going to do community service. But in your application, you need to highlight the fact that you are a dedicated family person. You've done the right thing. If you don't have a family, for example, you're applying for citizenship, you don't have a family, but you've been focused on your career, building your career, getting your education, gaining, achieving things that are constructive in the United States, that counts as well, right? It's owning a business, running your own business, employing other people in your business counts as some good that where you can qualify for US citizenship. So this is where I say get help, because don't count yourself out and get the right help to understand how you can move forward, because a lot of these policies are in place to make you feel like you can't qualify, and that's not the case. So Veronica, I don't see your question. You have to retype your question. I don't see it. All right. So now I'm on Instagram. Hi there, everybody. Thanks so much for waiting. I'm going to scroll through and answer some questions here. Let me see. So I also got a notice of cancellation of request for evidence and notice of final approval of N600, all on the same day via USCIS account. What does this mean? That sounds like great news. Sounds like they're not going to request the evidence that they initially requested. And instead, I don't know if you got that request for evidence, but maybe they were looking at asking you for something, and they after a second look they decided, oh, they don't need it again. They're going to approve your N600. N600 is certificate of citizenship. So basically they're giving you proof of citizenship. So congratulations on that. That's great. I filed N600 for my kids living with me in the US in her I'm not sure what that is. I got a notice for request for evidence. So yeah, so it sounds like great news. Sounds like you're approved. So that's great. Filing I-130 for my son, wife, and daughter. And I don't see anything else for Kitty Cakes. I don't see where the other question is. How long for I-130 approval? Family-based? It depends. If you're an immediate relative of a U.S. citizen, the spouse, parent, or son or daughter under 21 of a U.S. citizen, then you're looking at maybe a year and a half. If it's anything else, it could be years, because the usual process for those other categories of immigrants is 5 to 7 years. So it might even take 4 years, because they put that that is not prioritized compared to immediate relative of U.S. citizens, because the process does take about 5 to 7 years. My U.S. citizen daughter petitioned for me. Interview was done 4th September. My case says interview canceled. So I don't know if I'm not sure. I'm not your attorney, so I wouldn't be able to say what happened. It sounds like maybe they were going to schedule an interview and a second interview, and they've canceled it. So I'm not sure what happened there. But it sounds like you did an interview, and right now, they don't have any more need for another interview. And that has happened where they've issued those. Here at the office, they've done that to where they've issued interviews by mistake, and then they've canceled them. So it could be something as simple as that. I filed an I-130 while I was in ICE from October 2023 and yet to receive an answer. Is that normal? Yes, and I want it, but if you have been detained or you have removal proceedings, you may request an expedite to see if they can move it forward. And it depends on what kind of I-130 based on what family relationship. So it might be years before you get an approval on an I-130, depending on the family relationship. Can look my driver's license. I'm in Massachusetts as undocumented immigrant, but Massachusetts is one of those states that provide driver's license. Could I? And I don't see the rest of it. Keep in mind that a lot of so if you drive with that driver's license in other states, or even if you get stopped by ICE with a driver's license and they still sniff that you are undocumented, it's not going to protect you. So it's not going to, because you're driving with a valid driver's license, it's not going to cause any criminal offenses, but it may not protect you from being detained by ICE if ICE are the ones to stop you. How long do F3 green cards take now? So I'd say 14 year, 13 year, 12 years. I came 1 year ago from Portugal, Europe. I came with Visa ESTA, but I stayed over 3 months. Can I apply for some kind of legal status? So usually when I have situations like this and you don't have you're not the immediate relative of a U.S. citizen, I want to know more about your circumstances. So this is where it's very important to talk to us because we want to know, one, what led to the overstay. Did somebody convince you to stay? Did somebody give you a promise that they couldn't keep? Did somebody force you to do work for them? Were you working for somebody that promised to sponsor you and they never followed through? Was their intention to cause you to overstay and then get you to work for them? So we need to talk to you about circumstances to determine whether there are options available. Can a male file for VAWA? Absolutely. Males can file. This is for everybody, no matter your gender. You can apply for VAWA. Can a man, okay, so I answered that. Due to the shutdown, USCIS may delay work permits. So here's why the USCIS is not going to delay. The USCIS is based on fees. So their funding is not from Congress, it's based on the incoming fees. So while there are, yes, there are limited situations, sorry, there are situations, some operations under USCIS that may be shut down. It's not going to be where there are work permits or green card applications involved. That's because it's all funded by fees. I believe the immigration court, I'd have to check, but immigration court is funded by the federal government. And I know they have that may be affected. Immigration court, I'd have to check. But USCIS, which that's a question here, no, they're self-funded. Although under this administration, we never know. So I'll have to keep an eye, but that has always been the case in the case. And this is like deja vu, guys, because if you recall, back during the Trump administration, we went through this. There were government shutdowns and the same things happened. And here we are again. It's like full circle. And at that time, USCIS continued processing cases because they operate off of the fees that are paid in the applications. How much to guide N400 interview? So give us a call. Let's talk to you about where you are in the process, and then we can determine how we can move forward. My husband has been here over 10 years and don't have an port of entry. Does he have to go back home for me to file for him? So if your spouse has been here and did not enter with inspection, then adjustment of status through you will not be possible. And so, yes, if he doesn't qualify for other types of relief, and this is where I say we have had situations like this, and we have found where the spouse qualified for other options. So the spouse qualified for the T visa, for example, for VAWA in some cases, but you're the spouse. So I take it that you're not abusing your spouse because you're asking the question. But we have found alternative options for our clients. For example, we had one client, same situation. She entered without permission, but we found out that she had been trafficked, as in an employer took her into their home as a nanny and mistreated her, refused to pay her, locked her up in their home, wouldn't allow her to leave, and just forced her to take care of the kids and deprived her of food. That counts. Yes, even if it happened 30 years ago, it counts. And so it qualified our client to stay in the United States and apply for T visa. And here's the other thing: the T visa allowed our client to get forgiveness for entering the country without permission. And whether she's married or not, that while it definitely helps the case in some cases, it strengthens the ties to the United States. The most of it is focused on what happened to her. So we need to talk to your spouse to figure out what have they been through, what were the circumstances surrounding their entry, what did they experience, any other circumstances that would qualify them for other types of relief other than just going home with the I-601 or applying for I-601A waiver. That's another option, is to get the I-601A waiver, but that with that one they have to go back home for a short period. And then keep in mind too that they're right now under this administration, they're at risk for detention. How can I reach out to you? The number is going across the screen. We are 24/7. So you can call us if you're thinking about us all times a day. You can't sleep at night. You're in the middle of the morning. You woke up 4 in the morning. You're getting ready for work. You got a break from work in the middle of the night. Give us a call. We're here. The staff will schedule you for and do the initial evaluation to make sure there is a possible option, and then get started on we can then talk to you about some of the options after doing a full analysis of your situation, circumstances, qualifications. What is the term and condition mentioned on EAD for VAWA? So I'm not sure what that is, what the term and condition is. I don't know what you're referring to. What's the next step after I-130 approved for minor out of country? They're going to send it to the National Visa Center. The National Visa Center is then going to open up a immigrant visa application. They're going to request that an invoice be paid for the affidavit of support. And then now this is an important part, and I can't stress enough how important it is to follow the directions and make sure you're properly preparing those documents. One mistake at that stage can lead to a 6-month delay, and I'm not exaggerating. One mistake leads to a 6-month delay. That's because NVC will open up the portal. They'll say, okay, fill out the immigrant visa application, give us the affidavit of support, upload these documents. If you upload a document in the wrong formatting, if you do the affidavit of support incorrectly, if you even maybe don't submit a full immigrant visa application the way that they want it, it's literally going to take them 3 months to tell you that. Then when they tell you that after 3 months, they're going to say, oh, you need to do this, you need to do that before we can approve it. Then you're going to go back and do it, and it depends on how complicated the mistake is, how complex it is to correct it. You're going to go back, correct it. Say that takes you a day, maybe a week to get it done. Maybe affidavit of support wasn't as well done as it should have been. That's going to take you some time. And then you get it back to them. It's going to take them another 3 months to give you that approval. So make sure you understand how to do it at the NVC stage. It can really be frustrating and push out the timeline by 6 months to a year. I once had a client whose process should have been 1 year. It turned into 3 years. And half of that time was based on the client just making mistakes, right? That she could not figure out how to get corrected. Kept on uploading wrong documents, uploading the affidavit of support wasn't done properly. And because of that, they kept denying, and that just kept going on and on. Is USCIS still working about work permit for immigrants? Absolutely. We're still getting those work permits. Absolutely. That's the joy. That's one of my joys, is seeing those work permits coming in. Our entire team, legal team, celebrates each and every one that comes in. We celebrate. So trust me, I know they're coming in, and that's the best part of and that's what I try to do, is I try to extend the hope to you guys, because that's what keeps us going here at the office. That's what keeps me going, coming here and talking to you, is I see the hope, right? And you're out there, you're hearing things from all over the place saying, and some are true, some are not, but saying that immigration is dead, it doesn't make any sense. You apply for anything. If you apply for anything, you're going to be caught and detained. It's a trap. And it's not true. So look what you qualify for and work from there, because we are seeing results, guys. And it does change lives, it changes families, and we're doing it, right? So this is where I say, stay steady. Make sure you take action on behalf of yourself. The least you can do is start with a confidential appointment with one of the attorneys here at ST Law that can guide you to a solution, because solutions are there. Well, these are all great questions. It's such a pleasure to be here with you tonight. Thank you for your time. And now, can you speak a little about Jamaica and the student loan agreement signed with the U.S.? So this sounds like it's very much related to the J1, and that may, if there are student loan agreements that have been signed, then, and you're on the J1, that may affect your ability to get out of the 2-year foreign residency requirement. So that's what comes to mind when I see that. All right. Thanks, everybody, for your time. Our receipt notices for TVs are taking longer than 12 weeks. I would say there is a possibility that some could take longer. So I would say 3 to 4 months. So 4 months would be 16 weeks. So yeah, it could take longer, because we're seeing 3 to 4 months. Hello there in North Dakota. Wow, way up there. Thanks for joining. All right. Thanks, everybody, for these great questions. I'm going to be back tomorrow. So what I always say is like, subscribe, share, follow, hit the notification bell. And wow, we have 13.2 thousand likes. That, I think that's a record. Thank you so much on TikTok. And that, what you're doing is you're helping other immigrants to see this information that empowers them. And thank you, everybody, for your engagement, your questions. This is what keeps people engaged and keeps them seeing this information that can empower so many immigrants through their journey. Because as I tell my team, we are needed more than ever now. We're going to stay steady. We're not going to back down from this mission, because people need us more than ever. So get in touch with us. Let's talk about your legal solutions While these legal solutions are here, let's get it. All right. Thanks so much, Dameen. I appreciate that. I appreciate your support. Have a great, great night, everybody. I'll see you tomorrow. Bye bye.